Be ready. Now I am going to dictate a legal passage on judgment of Malda District Court for upcoming Malda District Court exam 2023 to 24 at the rate of 120 words per minute. Let's start. The decree sought to be executed in this case was made by the court of the Munship of Nawabganj, but the local jurisdiction in respect of the subject matter of this suit appears to have been subsequently transferred by order of the local government to the court of the Munship of Malda. Nevertheless, the decree holder took out execution of his decree within the time fixed by the law of limitation in the Malda court, and in the course of the execution a sum of money was paid towards the liquidation of the decree. A second application for execution was made in February 1899 in the same court, but the decree holder was referred to the Nawabganj court as being the court which had passed the decree and which was alone competent to execute it, in order that an application might be made for the transfer of the decree for execution by the Munship of Malda. When an application for execution was made to the Munship of Malda on a certificate transferring the decree to him, the judgment debtor pleaded limitation. The Munship overruled that plea and gave the decree holder the benefit of clause 3 of section 14 of the Limitation Act, holding that he was entitled to a deduction of the time during which the application erroneously made to the Munship of Malda had been pending, as he held that such proceeding had been taken in good faith. The district judge on appeal expressed a contrary opinion, holding that ignorance of the law on the part of the decree holder would not constitute good faith. The district judge, however, on other grounds affirmed the order of the Munship, holding that the proceedings erroneously taken in the Malda court were not absolutely void but voidable, and that the judgment debtor, having condoned the error committed by the decree holder and having accepted the jurisdiction by making part payment of the decree, that proceedings were saved under section 14 of the Limitation Act. Para. The first question raised before us in this appeal is what court was competent to execute this decree, and it is contended that the court of the Munship of Nawabganj was alone competent to execute it, being the court which passed it within the terms of section 223 of the Code of Civil Procedure. And it was also contended that although the Munship of Malda might now alone have jurisdiction to try the suit by reason of the transfer to his jurisdiction of the locality in which the subject matter of the suit is suited, he would not be the court to have jurisdiction to execute the decree passed by the Munship of Nawabganj as authority. For we have been referred to the case of Kalipada Mukherjee versus Dinonath Mukherjee, 1897, ILR 25 Cal 315. That case, however, is distinguishable from the present, for it was held that the district judge's order under clause 2 of section 13 of the Bengal Civil Courts Act did not amount to a transfer of jurisdiction, but was merely an order for the distribution of business amongst two courts, each having jurisdiction. In the present case, however, the order of transfer was of a different character. It was an order by the local government which readjusted the boundaries of two adjoining moujas so as to place the lands, the subject matter of the suit within the jurisdiction of the Munship of Malda. There was therefore no mere redistribution of business as in the case in IL Rule 25 Cal, but a removal of jurisdiction over this locality. The case of Lakshman Pandey versus Madan Mohan Shai 1880 ILR Cal 513 seems to us more appropriate in dealing with the terms of section 649 of the Code of Civil Procedure. Stop. Thank you.